Hi friends, welcome to the 8th class of IPC and this is Lokesh Pathak with you. The topic for today is offenses against public tranquility. Now in this category, there are three types of offenses which we will cover today. The first is the unlawful assembly, which we already discussed in the previous class of common intention and common object, because unlawful assembly is related to common object. Then the second topic we will cover today is rioting, and the third is the affray. So these all three are the parts of the offenses against public tranquility. Now the first one, which is unlawful assembly, I would just repeat it here in context to this subject, because earlier it was in the respect of common intention and common object. So the unlawful assembly, first of all, what are the sections of IPC which deals about it? The section from 141 to 145, section 149 to 151, section 154, section 157, and section 158. These sections talks about unlawful assembly. So quickly we'll make a recap of that, what we have covered in the previous class, because this topic belongs to public tranquility also. So the section 141, it speaks about the unlawful assembly, while section 142, it talks about the members of unlawful assembly. Section 143 talks about the punishment for unlawful assembly, which is 6 months imprisonment or fine or both, while 144 says that if this unlawful assembly is joined with weapons, the punishment can go up to 2 years imprisonment on fine or both. We have seen the case law in the previous class also related to unlawful assembly, but quickly I will recap it here. Section 149 says that any incriminating act to accomplish common object of unlawful assembly is punishable by law. Now the case law, the first case which we taken up earlier also, which is Roy Fernandez versus State of Goa. In that, Supreme Court held to determine the common object of the assembly, of the unlawful assembly. The circumstances which needs to be considered are: first, the incident, how it took place; second, the conduct of the members of the unlawful assembly; and third, the weapon which they use. So using the fact of the incident and the conduct of the members and the weapon they use, we can easily determine that whether there was a common object or not. This is in relation to the unlawful assembly. This was a finding of the famous case of Roy Fernandez versus State of Goa. Another case, which is Ramachandran versus State of Kerala, it was held that the common object may form in an spur of the moment and there is no need for the prior concert or consent among the people of the unlawful assembly. It is not necessary. So they can, in a fractions of second, they can have a common object and they can commit the offense. Another case, which is Vaman versus State of Maharashtra, and that it was held that one member of assembly, if he commits an act to achieve a common object and it is within the knowledge of other members, then all of them will be liable as per section 49 for the offense. So this is quickly the one which we discussed. So this was the first point here with the public tranquility, the offenses, that if any unlawful assembly is there, then the people will be accordingly liable. Now the second point here is the rioting. Rioting is included in Indian Penal Code under the section 146 to 148, 152 to 153, and 155 to 156. Section 146, which defines rioting, it relates it's with common object or unlawful assembly. Section 146 says whenever force or violence is used by an unlawful assembly or by any member thereof in prosecution of the common object, then every member of such assembly is guilty of the offense of rioting. So rioting is nothing but if any unlawful assembly or common object, it is added with the use of force or violence, then it becomes a riot. The punishment of rioting is defined in section 147. It is 2 years imprisonment or fine or both. Section 148 talks about the case where rioting is aided with arms or deadly weapons, and those weapons should be sufficient to cause the death of a person. In such case, the punishment will exceed to 3 years imprisonment or fine or both. Section 152 says assaulting or obstructing a public servant when he came to suppress the riot, the offense is big and the punishment is 3 years imprisonment or fine or both. While section 155 and 156 holds the person liable, it extends the liability to the person for whose benefit the riot is committed. So if for a certain person's benefit the riot is committed, and that person although has not participated in the riot, but the riot is going to cause benefit to that person, and for that purpose the riot is committed, then such person is also punishable for with a fine, and this is mentioned in section 155. Section 156 again holds the liability of such person for whose benefit the crime is committed. The liability is extended to the agent of such person. The agent of such person is also subject to a fine, which is mentioned in section 156. Now the third offense is affray. Affray is defined in section 159 and 160. Section 159 of IPC says that when two or more persons, by fighting in a public place, disturb the public peace, they are said to commit an affray. So this definition of affray, it gives you three components which are necessarily to be satisfied. The presence of two or more persons, the fight or quarrel between those persons in a public place, and third and most important is the disturbance to the public place is necessary. If they fight and there is no disturbance to public place, then it is not said to have been committed an affray. Now punishment for affray is imprisonment of just 1 month or fine of 100 rupees or both. Now there are certain cases in relation to that. That one is Babu Ram ILR 53 case. In that it was held that to create affray, mere fight is not enough, but it should create disturbance to the public peace. That's what I was just saying, that the fight is necessarily required to disturb the public peace. Then only it will be declared as an affray. Now what is the difference between affray and riot, which we have just discussed? You see, in affray the necessity of the fight is a public place, while in riot it can take place anywhere. So the presence in public place is required for affray, while it's not so for riot. The second difference between the two is, for affray 2 or more persons are required, but for riot at least 5 persons should be there, because it is the extended version of unlawful assembly, and for unlawful assembly, as you are aware, there should be at least 5 persons. Affray not necessarily unlawful assembly, but for riot, as I said, the unlawful assembly is required. This is the third difference. So this is all about all the three, which is unlawful assembly, rioting and affray, which forms the part of offenses against public tranquility. So this we have covered in this class, and in the next class I will try to take up the offenses against human body. Stay tuned. Take care. Bye.